anyway, you've got Douglas MacArthur there on the top left, and then you've got his revocable trust, and he had a lot of assets in this trust when he met me, and I explained to him that this trust is revocable. It had been a joint trust with his wife, but whoever drafted it didn't look ahead. They could have drafted it so when the wife died, it could have been held for his health, education, and maintenance, and it would have been creditor-proof and estate tax-proof, but that's not the type of trust he got. He got a trust that when his wife died, it was revocable by him, so it didn't do very much good. And by the way, I'm not the one who drafted it, so I can say that. Now, on the bottom, across the left, he has real estate LLCs, and he already had the LLCs, and he already had the real estate in it. It's rental real estate. But he owned those LLCs directly under his revocable trust, and he's in a business where he drives a business vehicle, and he could be sued. So what we've done is we've set up General Holdings LLC, and General Holdings LLC is owned partly by an irrevocable trust for his family and partly by him. An irrevocable trust is owned half of 1% voting, 2.5% non-voting. That's what V and non-V means. You probably thought it was Virginia and North Virginia, but there is no North Virginia. If you thought that, you were wrong. And then on the left, you've got 0.5% voting, 96.5% non-voting, owning this LLC, which in turn owns the real estate LLCs. Now, why do I have voting and non-voting? Well, for one thing, it's complicated, and I love complexity. But for another thing, when he dies, 97% of an LLC is worth 97% for estate tax purposes. But if he dies with only half of the voting rights, then we can take, on average, a 40% discount on the estate tax. Or if he happens to live in a state where a charging order law doesn't work, or they change the charging order law, they get a judgment against him, they still can't reach into the holding LLC because they won't have the voting rights. They won't be able to outvote him. So that's where we changed the voting rights. Okay, then he had one company. We had one company when we met a few weeks ago. Now he has 3 companies. Because he was very bright, and what he was doing in his business, and I use an example of a bus business. I used to have a client who had a bus business in New York City. And she had operations where she was maintaining buses for one of the boroughs. She had operations where she was providing drivers, which is huge liability exposure. And she had an operation where she was actually selling buses and rebuilding buses and selling them. So we divided that into 3 separate companies. So she had the bus maintenance company, the driver company, and she had most of her employees fit under one of these or the other. There's a little bit of overlap. Whenever one employee from one company helps the other company, they keep a time record, and at the end of the month they pay each other for that use. So now when a driver, goes off a bridge, unfortunately, and causes millions of dollars of liability, they're not going to lose their maintenance company, they're not going to lose their sales company, they're not going to lose their inventory. Their banks aren't going to already call all their loans in. So, this was good planning. Now, if it was one company with intellectual property, we might just move the intellectual property out. Okay, then I've got a 20-year lease where the rental, there's going to be a rent agreement between the 3 operating companies and the business company, 20-year lease, and if the lease goes in default because the company can't pay its rent and it has a judgment against it, then the landlord is owed 20 years rent and has a UCC statement filed against the company. So in other words, the landlord will own all the assets, and there's nothing there for the plaintiff lawyer but the liability insurance that hopefully Holly will make sure is in place. So that's where this is. Now, one thing we're considering is a Nevada Creditor Protection Trust. So Nevada has a statute, as do many of the states, I think there's 17 of them now, which say if you put assets in this trust, no one's chasing you at the time, creditors can't reach into the trust, even though you may be a beneficiary of the trust. So if you live in one of these states, and they're in the outline, by the way, North Virginia is not one of them, but if you live in one of these states, then this trust will probably work. If you live in Florida where we don't have these creditor protection trusts, a Florida judge may say that that's a bunch of malarkey and therefore the full faith and credit clause of the U.S. Constitution may force a Nevada judge to enforce that, and the trust may be disqualified. So what we do is, when we draft that Nevada trust, if I do one for Margaret, Margaret's not named as a beneficiary in the trust at all. It's only for her descendants, but the trust protectors, who happen to be her best friends, have the ability to add beneficiaries later who happen to be descendants of her grandparents, and that's written in the small print, and creditor lawyers aren't very smart usually, so they wouldn't even see it. And then that trust also could be a complete gift for estate tax purposes and be out of her estate. Now, this client probably doesn't need that. This client has plenty of umbrella liability insurance on the trucks and on the drivers, so you know he's probably not going to do that Nevada trust, but that's one of the potential.